The upcoming General Data Protection Regulation, better known as the GDPR, will impact cloud data storage providers all over the world, but the GDPR has an impact larger than even data providers. It has an impact on the law and legal implications around the transfer of data. For Tech Republic and ZDNet, I'm Dan Patterson with David Horrigan, Relativity eDiscovery Counsel. David, I wonder if you could tell me a little bit about first what Relativity eDiscovery does, and then we'll talk about the impact and the legal proceedings around the transfer of data.
Absolutely, Dan, and thank you for the time this morning, and thank you for having me. At Relativity, we've grown beyond eDiscovery. Originally, it was a software platform used by attorneys, paralegals, and legal technology professionals to review data for litigation. It's grown since then, and now it's a platform for investigations, eDiscovery, and litigation, and it's used by law firms across the world and corporations as well. There's the tagline, organize data, discover the truth, and act on it. But that's really what we do in many ways because it's used far more than in just litigation.
So the GDPR, help us understand the legal implications of storing data and the transfer and management of data.
Absolutely. And I think it's important not to consider the GDPR in a vacuum, and we've got to turn the clock back a little bit to understand how it all played out. In 1995, the European Union approved what is known as the Data Protection Directive, and it became effective in 1998. Under that directive, it provided some, by American standards, very stringent data protection requirements. But one good way to think of it is thinking about federal law and state law in the United States. The directive was an advisory directive to the member states of the EU. The General Data Protection Regulation is a regulation. It is more binding on the states. So think of federal law in the US that preempts state law in the 50 states. The idea behind it is to harmonize the law, make it almost easier to conduct business as opposed to dealing with various EU member states and having sometimes contradictory policies. The challenge for many US companies, US law firms, is that the regulation is much more stringent in some ways than the directive was. And so you've got the level playing field with some exceptions, but you've also got more stringent regulations under the GDPR.
And the different territories add to this kind of muddled mess, but how should companies make good decisions, or what precedents should companies follow in order to make good decisions, at least in terms of guidance until there's actual precedent on the books?
That's a great question, Dan. And one of the things you've got to consider is that the United States is not considered to have adequate data privacy and data protection standards under EU law. But there historically has been a workaround. It formerly was the Safe Harbor framework. And under the Safe Harbor framework, it's sort of an exception to allow data to be transferred. There was the Max Schrems litigation in the EU that invalidated the Safe Harbor framework, and a replacement came up, the Privacy Shield. So when thinking of them, you've got to consider, okay, will the Privacy Shield get me around the GDPR requirements? Probably not, and that's the issue. Good information governance is the first thing you can do. And that sounds overly broad and simplistic, but there are some specific parts of the GDPR that relate to information governance. The first thing that you could do is have a data protection officer. That data protection officer is a requirement for any government organization and most private companies. When they were negotiating the GDPR, there were discussions on who it would cover, what kind of companies it would cover, but it really covers most private companies as well as all government entities. So hiring a data protection officer, or if you've got someone in place who can fulfill that role, that really goes a long way, not completely. Another thing that we would recommend is having ISO 27001 certification. And that is a process promulgated by the International Standards Organization where you've certified through inspections that you're meeting adequate data privacy standards. And one of these things, when you think about information governance, it's something that you want to do anyway, but procedures such as this will help you comply with the GDPR.
Are there ways that companies can anticipate the cost of not just compliance, but retaining the heads and doing the research needed to become compliant?
The first big thing to consider is the potential fines under the GDPR. That has gotten a lot of attention because they're very substantial, up to 4% of global turnover, otherwise known as annual revenue. So the fines can be catastrophic in many cases. They've never been meted out before because the regulation doesn't take effect until May 25th of next year. So there, as you pointed out earlier, there's really no precedent on this yet. But the fines are the things that you need to do and look out for most notably. Second, there is obviously a cost to information governance. When I was at 451 Research, we did surveys on how seriously companies were taking information governance preparation. People in the trenches placed a high value on it. People who are in IT, people who are working in data security, the lawyers, for instance. But we found that when you got to the C-suite, the number of respondents who thought it was a priority really went down drastically. Convincing senior management to get on board, having that data security officer or DPO is key. And then when you figure the cost, you're going to say, boy, this is going to cost me a fortune. Non-compliance is going to cost you a lot more than that. And once again, you can't stress these things. Having a data protection officer, having a privacy policy, a data protection policy, are things you should really do anyway. So I think it's ingrained in the cost of doing business, but those fines are a real concern.
So, David, this may sound like a very fundamental and even silly question, but I want to paint a contrast here. If I'm a Western company, why do I have to comply with a regulation that was enacted by the European Union?
It's actually a great question, Dan, and that is because the GDPR does not only apply to businesses in the EU, it applies to businesses who are controlling or processing data of EU citizens. And data, as you know, do not know national borders. And if you're a company of any size, chances are you are going to be involved with at least processing data, personal data that involves EU citizens. So it's, from the legal standpoint, it is of great importance in cross-border business, cross-border banking, those sorts of things. But even if you are a smaller business, you need to keep those things in mind.
Now, you already painted this contrast for me and hinted at it a moment ago, but what are the benefits of GDPR compliance?
Uh, you know, it, as we said, it's a really important part of information governance, and it gives you a better handle on what data you have and what you need to do about that data. It's good for your business because it builds trust in people knowing that you're handling their personal data in a satisfactory way, as the Europeans would call it, an adequate way, meeting the adequate EU data protection standards. But you can have these things, and it streamlines your operations. You know what you have. If you have a data protection officer working with the data, if you've got a data protection policy, if you're going for ISO 27001 certification, it really streamlines your operations, gives you that sense of confidence, and knowing that not only are you compliant with the law, it makes sense from just a pure business standpoint.
Relativity e-Discovery Counsel and Legal Content Director David Horrigan, thanks for your time today. David, I wonder if you could leave us with some advice on getting started. What's step 1 and 2 of complying or making sure that my data is compliant with the GDPR?
The first step is knowing what you have. I know that sounds overly simplistic, but many organizations don't even know what data they have in-house. So knowing what data you have, you can create a data map, you can do any number of things. The second thing is obviously once you know what data you have, whether you're a controller or a processor, then you go forward, get the data protection officer in line, get your privacy policy down, and consultants outside are a great suggestion as well.